Hi, my name is Paul Stradowski, president of HR Partners, a New Jersey human resource consulting firm. We recently sponsored a webinar on the new New Jersey Equal Pay Act. I've gotten some feedback that the webinar was too long and too legalistic. One of my favorite quotes is from Abraham Lincoln, who, after writing a 5-page letter to a friend of his, put a PS down the bottom that said, "Sorry, I didn't have time to write a shorter letter." So I've taken the time to come up with a condensed version of the webinar, basically to give you the highlights of the law in just a few minutes. I hope you find it useful. Here's the key provisions of the new New Jersey Equal Pay Law. First, it applies to all New Jersey employers, regardless of size. Second, monetary damages are much higher under this law than under the federal act. Damages could go back 6 years from the time of the first discriminatory action. Triple damages could be paid if found guilty. This law requires a greater burden of proof on the part of the employer. Under the Act, the employee is required basically just to show that they performed similar work to another employee but was paid less. It's then up to the employer to prove that the action was not discriminatory. The pay comparison is to similar work rather than the same job as under the Federal Pay Act. This is much broader. Several states have written similar language into their state laws and have had difficulty determining exactly what is comparable work or similar work. It could be certainly something that would be more complicated and more difficult for employers to comply with. Many companies have salary grades, and within a given salary grade, there could be several jobs. One practice called broadbanding has many jobs within the same salary grade. Could this be considered similar work under the law? The Act prohibits employers from retaliating against any employee for discussing pay with any other employee. That could mean that your employees would have more information available to them than what they have currently. Excuse me. The law allows individual pay differences based on job qualifications, education, and experience. However, I recommend that these be documented in writing and that individual pay increases that may vary based on performance, that the performance be documented with specific examples or against agreed upon measurable standards. That is basically to protect the employer from a lawsuit. Now, understanding the law and determining if your policies are in compliance are just the first steps you need to take as an HR professional. It is necessary to determine whether you have inadvertent pay discrimination and then decide steps to adjust the pay of specific employees to meet the requirements under the law. These steps are extremely complex and generally require the outside expertise of a compensation specialist like myself. We have been dealing with equal pay issues for over 20 years with companies like yours. To learn how we can better help you, please give me a call at area code 908-763-5699. Thank you very much.